In the previous trial, you stated that there were 8 police officers at your home on May 22nd. Do you remember that?
That trial was 6 months ago.
Your Honour, can I please get a stipulation from my learned friend that the witness did give evidence that there were 8 police officers at the witness's home on May 22nd?
I stipulated it.
Thank you. Do you remember in that trial, the previous trial, that you gave evidence that 2 of those officers at your home were female?
Yeah, there were 2 female officers there. I'm not sure I said that during the other trial. I suppose I did, I mean, it was true.
And do you remember giving evidence at the previous trial that one of those female officers at your house on the 22nd of May had freckles?
Is that relevant?
Yes, Mr. Brown. Is that relevant?
I would argue that it is, Your Honour.
In what way?
Well, Your Honour, there seems to be some inconsistency.
What? About freckles?
Well, yes, Your Honour.
The jury's excused.
I believe inconsistencies in her memory could rationally affect the probability of a fact in issue, Your Honour. In this case, Your Honour, our narrative, which is an alternative to the Crown's case, is that Ms. Q and the victim staged the assault in order to frame my client. Therefore, the circumstances shortly after the police arrived on the scene are highly relevant in going to the facts in issue in our case.
Whether or not one of the attending officers had freckles or not, I mean, you know, and more to the point, whether or not Ms. Q stated that she did during the first trial of this matter has no relevance whatsoever.
It also goes to credibility.
There will be ordinary variations of memory, Mr. Brown. Whether or not she actually recalls freckles has no bearing on credibility or, in fact, an issue in this case. I advise you to revisit section 55 in future, please.
Yes, of course, Your Honour. My apologies.
Thank you, Mr. Brown. The jury may return.
Miss Q, do you remember giving evidence that one of those female officers at your house on the 22nd of May seemed to lisp a little bit?
The jury is excused. Please stick to relevant questions, Mr. Brown. I don't know what instructions your client's giving you, but please remember section 135 of the Evidence Act. I do have the power to exclude evidence which causes or results in an undue waste of time.
What did you think of Mr. Brown's performance?
Well, case management principles dictate that I exclude evidence that causes or results in, undue waste of time. Mr. Brown went on for 4 hours. He wasted the court's time, no doubt about it. You really seem to be tilting at windmills there, Mr. Brown.
Ah, well, you can't make silk purse out of a sow's ear. I did get the witness to admit one untruth, one lie, and that was a beauty. But at the same time, it really didn't make much difference. The lie had no material bearing on the case, and the rest of her testimony was pretty consistent. What do you think of Mr. Brown's performance?
Poor chap. He really didn't have much option but to do as he did. The witness was a good one from our perspective. She gave her testimony and stuck to it tenaciously. So all my learned friend could really do was focus on the minor inconsistencies in her prior statements, and they can be explained by the vagaries of memory. Will the witness please state her name for the record?
Chastity.
Your last name?
Chastity?
Can you please describe your relation to the accused?
We're friends.
And how long had you been friends with the accused before he was arrested?
A while.
A few days, a few months, a few years?
About 45 minutes.
When you met the accused, what did you do?
We just talked.
And what was the accused doing? Was he just talking?
Pretty much. He kept sharpening a knife, though.
Your Honour, once again, I must protest. This witness's evidence is unfairly prejudicial to my client.
Can the jury please step out?
What does it matter if he was sharpening a knife? Hasn't every man sharpened a knife from time to time when he's talking to his lady friend?
Your client is charged with throwing a knife at a man 22 times. The knife was described as being similar, very, very similar to the knife the victim described in testimony yesterday. Then, Mr. Brown.
I also object, Your Honour, to Ms. Chastity's evidence in its entirety. I put to the court that it is most unfairly prejudicial, and I move to have the jury dismissed.
On what grounds?
She's a prostitute, Your Honour.
And?
There is a serious risk that the jury will use the evidence in an unfair way, reacting emotionally to the evidence of a prostitute.
Well, I see you have read the ALRC report, and Cosmos, you all know that evidence is not prejudicial merely because it damages your case. The jury is bright enough to realise that visiting a lady of the night is not really evidence of anything.
Then, Your Honour, I believe her prior convictions should be tendered as evidence, as they bear on her credibility. Section 103 of the Evidence Act provides an exception to the credibility rule if it could substantially affect the assessment of the credibility of the witness.
Prior convictions relate to solicitation. I see no element of fraud or deceit that bears upon the truthfulness of her evidence here.
Well, Your Honour.
In any event, Mr. Brown, you excluded a rather significant part of Section 103, namely that the exception applies only during cross-examination. We will deal with your application then.
Of course, Your Honour.
Were you happy with the witness's testimony?
Miss Chastity was helpful. We're glad we got the evidence about the knife in. The police never found the knife, or the gun. So we really need to get a weapon in, even if only psychologically.
What did you think of the witness's testimony?
She put gum on the witness stand.
Yes, she did. You allowed the evidence in. You allowed the witness to give testimony about the knife. It is prejudicial to the accused, but you didn't think it unfairly prejudicial. Why is that?
Oh, look, Mr. Brown may appeal that point if his client is convicted. I don't think he'll be successful. All evidence against the interests of an accused is prejudicial. Just look at what McHugh said in Papakosmos. To be unfairly prejudicial, evidence needs to contravene Section 137 of the Uniform Evidence Act. In a criminal proceeding, the court must refuse to admit evidence adduced by the prosecutor if its probative value is outweighed by the danger of unfair prejudice to the defendant. But in this case, the knife has a high probative value, so I allowed it in. The witness's testimony was quite clear. It was a distinctive knife, and she seemed to remember it well. It sounds like the same knife the victim described. So, like I said, it had a very high probative value.